Welcome everyone. I'm Ashley Berman, the Business Development Manager for Capital International Group. I'm joined today with Ulrich Strandvik from GSR Law, and today we're going to unpack a key topic around donation mortis causa, or a deathbed donation, or a deed of donation. There's quite a few terms that we use to describe this, and I think this topic really got a bit of hype post our Invest Talk session that we hosted, and you dug into it. But I mean, we've implemented some solutions around our products and our services that make use of this this feature. And Ulrich, I was hoping that maybe you could describe to us exactly what is donation mortis causa and how does it work? Or, yeah.
Yeah, thanks, Ashley. Good to be with you guys again and having these discussions. Yeah, so donation mortis causa, also known as a deathbed donation, you mentioned it, is a donation made in contemplation of your mortality, where someone considers their mortality. It could be on their deathbed, it could be while they're still alive and healthy, but just contemplating their mortality, where you donate an asset subject to you dying.
Yeah.
And it only comes into effect when you're dying, and you have the right to revoke it at any time before you die. That's a very crucial aspect of a donation mortis causa. It's a Latin term, meaning a donation on your death. And it's got to be distinguished from a donation inter vivos, which is your standard donation during your lifetime when you donate to a church or a mosque or the like. That's a donation inter vivos. And that's really how it works.
So it's a clear distinction between those two. But in principle, it's like you say, you can make this donation, but you don't have to be on your deathbed to do it. So it's not like a doctor has to tell you you have 2 weeks left to live before you can implement this type of decision. This could happen 5, 6 years, 20 years before your death, in that case.
It's something that people would think that people do on their deathbed. That's why there's a deathbed donation. But someone who maybe had a near-death experience or thinks about these things deeply and considers, I want to give this to this person. The key aspect of any donation is that it has to be gratuitous. It has to be benevolent. There's no strings attached to it. I just want to give this to someone as a donation.
So in other words, I can't necessarily use it to cede against a loan or a debt or anything like that. This would naturally have to be, in the event of my death, I donate this asset to you. No strings attached, no contracts tied to it or anything like that. It is purely gratuitous.
Yeah, absolutely. It cannot be contingent upon some condition. It is contingent upon, obviously, you dying, and revocable. That's a key element. But it can't be because I have an obligation to this person or because I feel that I have to. And this is an interesting thing to talk about because it's akin to a will because it happens on death. So the formalities have to be like drafting a will in South Africa, and that's quite strict. We can go into those details, but I don't want to bore you. But it's got to be gratuitous and not a testamentary disposition. You can't say, "Oh, well, you, my child, I'm going to give you my estate." It's got to be a gift. It's got to be gratuitous because I just want to give it to you. There's no obligation to give it to you, and that's very important. There's been case law where some people have tried to argue that a bequest or some testamentary disposition was actually a donation mortis causa, and the courts have said no. You intend it to be an inheritance.
Yeah.
So it has to have that gratuity element to it.
Great. And I think looking at the context in South Africa, I mean, we're quite familiar with many state institutions and so on like that have their own challenges. And I think many of our listeners or people watching this today would have had to wind up in a state and so on. And at some point, they would have had to deal with the master's office, and I think we can both agree that that's not necessarily always a pleasant experience. So taking that into account, what impact would that have in dealing with the master's office if you use a donation mortis causa? Yeah.
Yeah, I think that's a very good question, and I think there's an opportunity here. So there's that saying that necessity is the mother of invention.
Yeah.
We are living in a time in our lives where our state departments aren't delivering. There are states that are stuck in the master's office, getting appointed as executors. I mean, I mentioned this at the Invest Talk. People that are relying on inheritances to come through are not receiving their inheritances, and it's because the process is just afoot. It's dysfunctional. Things aren't getting done. It's taking, easily 2 to 3 to 4 years to wind up an estate. So the question you've got to say, can we use a donation mortis causa to bypass the master's office completely? So to expand on that a bit, if you don't mind, if you give a donation mortis causa, the principle is that you've donated it during your lifetime, but it takes effect on your death. So that means that it's not part of your estate, but it's wound up after you die. So the master then won't need to know about that asset, or it's not part of your estate, so therefore it's not in your inventory, and therefore you don't need to declare it, and you can wind it up apart from having to go through the master.
Which is really interesting, and I think that would put a huge amount of relief to a lot of people that have had to deal with these kind of estates. Yeah. But building on that, so if the deathbed donation or the donation mortis causa is outside of the estate, is it still estate dutiable?
Yeah. Also a good question. You're full of good questions today, Ashley.
Yeah, so we've had these questions drafted by many other people who watched.
Yeah, exactly. The people have asked this question. So yeah, that's a good question. So the idea of a donation mortis causa, and this kind of confirms that it's not part of your estate, is that although it's out of your estate, there's a deemed provision in the Income Tax Act, that says that it's a deemed asset. Just like life cover, that's a deemed asset in your estate. So even though you donate it during your lifetime and it takes effect on death, it's not part of your estate, but it's a deemed asset for estate duty purposes. So it's not a tax dodge in any way. It's really just to avoid having to go through the administrative burden of winding up an estate.
So in saying that, the executor of the estate wouldn't necessarily need to deal with the administration of dissolving the asset or distributing the asset, but they would just need to take the value of the asset into account with their estate duty calculation.
Yeah. That's a good point, and I think a good example is Capital International's investments that you're offering, where you're offering this donation mortis causa, is that you do the winding up. It's done with Capital International. The executive doesn't get involved at all. Yeah. So it's, however, they do need to take that into account when doing the estate duty return to SARS and to the master to show that it is there. But that also brings us to the next point about executor. If the executor has to then wind up the asset, can they charge a fee on it? So that's a good question, because just kind of backtracking a bit, when you pass away, you appoint an executor, and that executor is tasked with administering your estate, and they are entitled to a fee on the total assets of your estate. And the kind of guideline is 3.5% plus VAT. That is negotiable. However, it's only on the value of the assets in your estate. So if you do a donation mortis causa and the asset falls out of your estate, essentially they're not entitled to charge. So I might be talking myself out of a job here, because I am an executor for few estates. However, if I am winding up the asset post-death, then I can negotiate a fee for winding up that specific asset with the heirs. Because you, as an executor, you step into the shoes of the deceased to give effect to the donation.
Absolutely, yeah. Another question that came up building on that is, yes, I've got a highly liquid asset, my CIG custody accounts sitting flush with cash. What if my estate's insolvent and I donated this asset, would that have an impact there, or?
Yeah, yeah. I've been contemplating that question for a bit because you do have insolvent estates, and the whole idea of actually administering an estate, well, the whole of one of the important aspects is that it gets advertised and people know about the person that's passed away. So if you have a claim against the deceased, you can then come bring a claim against the deceased, against their assets. Um, However, if you've donated that asset, prior to death and it's been transferred, you have, there goes your claim. So it could be seen as a way to, avoid having to pay your debts you donated before you die. Yeah, so I think there, in that case, you would look at the Insolvency Act, looking at avoidable dispositions. So where you give over an asset in contemplation of your insolvency, so you give it to your wife or you give it to your family to avoid the consequences of having to pay that person. That person, that creditor can go to court and avoid that transaction. So I think that's something that needs to be investigated firstly, and also you have as a creditor recourse in terms of the Insolvency Act. But it's something that is interesting to engage with because it can be used as a way to avoid having to pay your debts. So that's the negative side of it.
Sure. And I think it always goes back down to you could have a solution like a BMW, right? It can go 200 k's an hour or 300 k's an hour on the highway. But should you drive that speed? Probably not. So you can use the solution for the wrong purposes, but ideally, that's not what the solution's designed for.
Correct.
At the end of the day.
No, correct. Yeah, true. For anything, people can use it for means that's not what it's intended for. So that's a very good point. Yeah, and I think that's something that you have to always be careful of is the flip side of something. But for me, it's something that hasn't really been tested. That one of the questions that came up is if this is so, and this is such a solution for us, why hasn't it been tested? And I've done a lot of research and I've looked at some case law. And look, I invite colleagues out there that have dealt with this, seen the pitfalls in terms of administrating the estate, and the problems that arise with the donation mortis causa, to engage and see, is this a solution for the problem that we're having at the master? Because ultimately we need delivery, and if we can avoid having to go into the master's office, wait 2 to 3 years for an asset to be liquidated. You don't have to do your entire estate. You can do a portion of your estate to make it liquid and get the assets into the hands of the heirs.
Absolutely. And I think just building on that as well, I think now that we've got a bit of a better understanding of what donation mortis causa is and how it works and what's possible, let's maybe unpack what it looks like, right? So generally this is an agreement or a document by a donor and a donee, and it stipulates what needs to happen there. Are there any other parties involved in this, or is it as simple as that?
Yeah, you got a donor and a donee. Because it's in contemplation of death, it has to follow, as I said, the strict formalities as you do with a will. So there have to be 2 witnesses. You have to sign every page of the deed of donation. The donor must give it gratuitously, and it must be in contemplation of their death, and it must state clearly that it is revocable. It's very important. It has to be revocable, otherwise it's not a donation mortis causa, it's an inter vivos donation. So you have to have the right to revoke it, and also the donee must accept it in donation. And also an interesting point on that is that if it's unclear as to whether this donation is a donation mortis causa or donation inter vivos, it's a presumption against a donation mortis causa. So you have to make it very clear that this is a donation mortis causa, and that's the revocability of it, and that it's gratuitous, completely and utterly gratuitous, and it happens on my death.
Looking at the witnesses in particular, do they need to be majors or minors?
Yeah, no, it's don't majors. The age is 14. Yeah, to be a witness.
and building on that, naturally similar to will, they can't be beneficiaries in the will.
Or
Correct?
yeah, or a donee. The donee can't also be a
witness.
witness. Yeah.
Okay.
Yeah. So it's interesting. It's quite different to a will because you have lots of parties in the will. You have an executor. You have a legatee. You have a beneficiary. You have an heir. Those can all be different parties, and if they witness, then they can't inherit.
Sure.
Whereas a donation is just two parties, and you wouldn't also be the witness to the donation, Mortis Causa.
Great. I think that really gives us a good understanding of what the agreement needs to look like and the shape and the form of it, the parties involved, and so on. Now I think it comes down to signatures and the good old John Hancock. You know, so must that be a wet signature on a original document? Must it be safe filed in a safe place? Can digital signatures be used? I think there's a lot to unpack around that.
Absolutely.
Yeah.
The Wills Act is expressly excluded from the Electronic Communications and Transactions Act. So you cannot sign a will or a testamentary type document electronically. So it has to be in wet ink.
Okay.
And you can't get around that. Otherwise it'll be invalid. And on that note of the witnesses, is that the witnesses must be present in the room when you sign that document. Okay. That's crucial, that they see you sign. And the witnesses must also be in wet ink.
Great. So I think we've looked at, I'd say, I wouldn't call them a party being the witnesses and the signatures, but we've covered witnesses quite well. Let's dig a little bit into the donors and who they are and what they can be. So can a company or a trust be a donor? Must it always be a natural person?
Yeah, it's a natural person.
Natural person only?
Trusts. Well, I suppose a company can donate inter vivos, and a trust can donate inter vivos, but a trust doesn't die, a company doesn't die. So therefore, you can't do a donation mortis causa as a trust.
Sure.
Yeah, unless AI develops some sort of way of doing that.
Well, touch wood, it might be the case with how those things are advancing.
Absolutely, yeah.
So donors need to be natural persons, but do donees need to be natural persons? So can I donate to a company or a trust upon my death?
Yes. Yeah, that's fine. It doesn't have to be a natural person. It can be a legal entity, it can be a trust. As long as you're authorized to act on behalf of the company or trust to accept that donation. Absolutely.
And in saying that, the donee needs to sign the agreement, sign this donation mortis causa as well, right?
Yes,
I mean,
correct.
like on a will, your inheritors, people inheriting don't necessarily have to sign.
You have to accept the donation.
Okay, all right. That's a key nuance.
It's nuance to the difference between a testamentary or a will to a donation mortis causa.
Very interesting. So moving off of that, so is this only available to South Africans as the donor? Can an offshore company, an offshore individual be donate mortis causa?
Yeah, it's a South African law principle. So if the asset is in South Africa, you can donate it as a non-resident or someone that lives offshore can donate an asset in South Africa. But if it's an asset in the other country, then the law of that country will apply.
Sure.
An interesting thing that if you're non-resident for tax purposes, you don't pay donations tax. But that's a key element we actually forgot to mention. Is that because the asset is a deemed asset for estate duty purposes, there's no donations tax for a donation mortis causa, whereas a donation inter vivos, anything above 100,000 rand,
subject to
donation tax of 20% up to 30 million, and above that at 25%, unless you obviously donate to a tax exempt entity or person.
which could have some advantage for somebody that's tax immigrated.
Absolutely,
that
as a
instance.
non-resident.
Yes,
Absolutely.
as a non-resident. Yeah.
Yeah.
Looking into that further, just into some of the other questions that we have. So, is it possible for the beneficiary receiving the assets or the donee?
Yeah, very
to-
important not to say beneficiary because then it's not gratuitous in that
Yes,
sense. You know,
yes.
it seems okay, now you're leaving something to me as
Yes.
inheritance. You know.
So they definitely donee. So
Yeah.
is it possible for that donee to be an offshore company, a trust, or an individual for that matter as well?
It can be any person.
So I think the nuance lies around jurisdiction is that the donor has to be South African, and their estate and assets need to be wound up here in South Africa for the law to be applicable to them.
Yes, yeah.
But the individuals receiving the assets don't necessarily have to be.
Correct, yeah.
And they can be anywhere in the world for that matter.
Correct. That's a crucial point. The fact that a non-resident donor owns property in South Africa, it's irrelevant because you don't pay donations tax anyway. So you don't necessarily need to do a donation Mortis Causa because you don't pay donations tax anyway. So yeah, that's a good way of putting it. South African donor, that's governed by the laws of South Africa, and the donee doesn't have to be a South African resident or South African citizen. It can be any person.
Another key question that often comes up now is from a lot of the advisors and the clients that use Capital International Group. Traditionally, they would set up joint accounts between husband and wife or partners or so on along those lines. So there, at any given time, the owner of the custody account, there could be more than one. So how would a donation Mortis Causa apply in a situation like that where there's joint accounts? Yeah.
So with the joint accounts, the good answer from any lawyer will be it depends. So if you've got a joint account holder, you can bequeath your portion, not bequeath, I mustn't use that word, but you can donate your portion to the other joint account holder in terms of a donation Mortis Causa, and the rules will apply. However, you've got to consider the nature of that joint account holder. If it is your spouse, then it's not necessary to do a donation Mortis Causa because your spouse inherits that free of estate duty, free of donations tax, free of, it's complete exemption for the so then I wouldn't do that. It's not necessary. And then I would do that at the point when the last dying.
Yes.
And then at that point in time, the donation Mortis Causa kicks in. So that, if I'm the last dying of my wife and I, the account holder, then I donate my asset to XYZ. That's how I would do it.
So building on that, if I have multiple custody accounts, so let's say I have, with CRG as an example, I could have 3 or 4 different custody accounts for different purposes and reasons on my underlying assets or my portfolios that I hold. Could I set up a donation Mortis Causa that covers all of those as a whole, or would I need to do one for each and every custody account? Because is it specific to the asset or the custody account, or is it specific to, can I do one that lists a group of these custody accounts or a group of assets for that matter, which we could maybe build on post that?
Yeah, you can. I would say it depends on how you want to structure it, and it depends on who you want to donate the asset to. If you want to donate it to one person or multiple people, but in my view, the simpler the better. If you're going to donate your assets to one person, you might as well put it into one document. It's straightforward, unless obviously the way that document is dealt with or the way that asset is dealt with is different. Sure. As long as the asset is dealt with the same for your kind of internal purposes as CIG. But I can donate multiple assets in one deed of donation that takes effect on my death. My house, my car, my cash, my bank, my CIG investment, I can put it on one deed of donation. So yeah, you can do multiple.
Sure. And looking at that, I think that builds into my next question. So a CIG custody account would be naturally seen as a highly liquid asset, or in my estate, it's generally a portfolio of shares and so on like that. But what about less liquid assets like a car or a house or
Yeah.
or something like that? 'Cause generally, you would need your executor to maybe sell it or list it or get an estate agent to dispose of those assets. But
Yeah.
donating it to someone that takes that sales aspect out of it, but
Yes.
naturally, there's still other
Key
aspects
elements. Yeah.
around that.
Yeah. That's a interesting one. It's obviously easier when it comes to a cash or a liquid asset like the CIG. It's straightforward. You don't have to involve the executor. It's all done in your back office, and everything's done properly.
Yeah.
And without having to involve too much paperwork. It does get complex when the delivery of the asset requires the involvement of the executor. So the asset is donated during the person's lifetime, and it takes effect on death. So that means the executor has to step into the deceased's shoes to give effect to the donation. And that's when they'll have to get authority from the master to act on behalf of the estate and then give effect to the sale of the car, the transfer of the asset, the house, for example. And that's where it will be interesting to see how this works out in practice, is how does the master deal with that? Because the master, if you sell an asset and you're acting as an executor of an estate to sell that asset, the master will have to endorse that power of attorney to pass the asset, but they don't have the asset in the inventory, so it could complicate things. You'll have to probably discuss it with the deeds office, saying you're acting in terms of a deed of donation, not in terms of an estate asset. So that'll be interesting to work out. So it is more complex. I don't think it's impossible, but those harder assets like cars, especially immovable property,
Sure.
you're gonna have to do your homework,
Yeah.
and make sure that the delivery of that asset is possible, and there's no bar to that.
Great. Then building on that, I mean, if I were an executor at the end of the day, I'd be quite livid that this large portfolio of assets is not included in my estate duty fees and so on.
Yeah.
Do you expect much challenge around that or complexity around that? Yeah.
Yeah, that's something I've also contemplated for a bit, and as I said earlier, probably talking myself out of a job here, but they are just doing it for your fee is not, you act in the best interest of your client, and best interest of the estate. If this is going to help avoid heartache, avoid someone not getting their asset in time, getting their money into their hands quicker, then that's just something that the executor will have to live with. If the executor does get involved in the winding up process, then sure, then they can charge a fee, negotiate that up front, and make it part of the planning up front. And yeah, look, it probably get a lot of people's noses out of joint in terms of not getting the full fee. But once again, you've got to look at what,
Have you really done the work?
Exactly. Have you done the work as the executor?
Yeah.
If you've done the work, then absolutely charge for the work.
Yes.
But if it's not part of the asset estate and you haven't touched it, wound it up, then you can't charge for it.
Yeah. And I think when you look at the way it would apply to a CIG custody account in that instance, because CIG is doing the work, you're really just including one additional line in your estate duty calculation. Does that justify 3.5% in fees to that, to facilitate that? And I think that's where those questions need to be asked.
Exactly. Yeah. I think it'll be a good discussion for an executor who is involved, or not an executor, but a deemed or a nominated executor involved in someone's estate, to discuss this with their clients.
Sure.
If it's an option for them to make it better for their heirs at the end of the day, discuss it, and maybe discuss a fee that you would charge if you're going to administer the estate. So I think that also leads me on to another thought, actually, is that if you are doing anything to avoid paying tax, or a scheme of arrangement to avoid having to pay a debt, that's always can be attacked
Absolutely.
or or challenged in court or any of the like.
Sure.
And the key is that it's got to be divorced from a will, a legacy, an inheritance. It's not to say, okay, I want this is my will. It's not your will. It's a gratuitous, benevolent act on my behalf because I am contemplating my death. It's got to make it very clear, because all the challenges I've seen in the court cases around this issue is that people have challenged the benevolence of it. That it's just another bequest. It's just another bequest, masked as a donation, Mortis Causa. So it's very important for the client to understand that it's just benevolent. It's something that I want to give. I want to, which is a nuanced argument, because you are giving your estate to your family out of benevolence, but also there is a sense that it's my family. I've got to give them the inheritance. So it's interesting debate, the benevolent nature of an estate versus benevolent nature of a donation.
Sure.
So just make that clear in your mind as a donor, that don't see it as your will, see it as a donation.
And once again, it's like you say, you don't want this to be a will in disguise. It's a donation. It's not a will in principle. Right?
Correct.
Though it's easy to connect the dots between the two, they are separate things entirely. And that builds onto another key nuance. Like in a will, I could say, if I pass away, please donate. Well, I want my sister to receive my assets. But if my sister's not alive, give it to my stepsister. Right. So like a contingent beneficiary. In this instance, I don't think you can do that, because then how do you apply conditions?
Yes, exactly. It's conditional. So that's a good point, and I would agree with you. I think that's something that a person contemplating this must take that into effect, because a donation is a donation. It's gratuitous. If it's contingent upon something else, if you die, before me, and then must go to this person, or if you die after I die, then I must go to this person. Then it's not gratuitous. It's not benevolent. There are strings attached. So that's a very good point. Actually, I think that people need to understand that if you've got a legacy asset that you want to pass down, or make sure that no one else gets it, don't want to spouse it to grab it, or just make sure that you get the right advice.
Sure.
That you know that this is going to my wife, to my children, and that they can do whatever they want with it. You can't rule from the grave with the donation, Mortis Causa.
Correct. Yeah. You and I also had a brief little discussion around after Invest Talk, particularly on the Master's Office. And what kind of struck me was, naturally, you have to do a bit of additional admin, and you can maybe talk around this on if my estate is valued at more, I believe, than 250,000 Rand. But now if my assets have been donated out of my estate and they're not part of my estate as far as the Master's Office is concerned, I can drop below those thresholds. Maybe do you want to unpack that a little bit more?
That was a good discussion we had. And what's important to understand when it comes to an estate is that if your estate is under 250,000 Rand, you don't have to, we call it a full-blown estate, so you don't have to go through the process of advertising, having a liquidation distribution account, which thing is advertised as well, and you have to account to the master of every kind of spend you've made. If it's under 250, they call you the executor a master's representative, and you get letters of authority, not letters of executorship, and then you can wind up the estate very easily with minimal cost and minimal admin. So if that is possible for you and your estate to do that, then that's a great way of minimizing the admin around your estate. Once again, you don't have to cut out your executor. If your executor, or what you call your master's representative, now has to deal with the asset post-death because you're a master's representative, you can deal with the asset and charge a fee. yeah, so that's really kind of the crux of it for me. Is there a way for us to bypass the master, or have a light touch with the master?
Yes. Simplify the whole
Simplify
process.
the whole process, because
Yeah.
it really is, to put it plainly, a disaster.
Mm.
I'm putting this on air. It's true. The master needs to get better, and until they do get better, this is a potential option for clients.
Now, that aside, let's look at, can this be challenged or contested, right? So, using an illustrative example, let's say I've set up a will 5 years ago that said all my assets are payable to my wife, and then I've since had a child 2 years later, and I've implemented a donation Mortis Causa on my custody account. Would the will not contest what was said in that
Donation,
deed of donation?
Yeah,
Yeah.
yeah. That's also something that you have to engage with, and generally, you can dispose of your assets during your lifetime, and even if it's in your will.
Sure.
So I would say that that spouse or that person who's inherited in the will, and that asset is subsequently donated through donation Mortis Causa, that they can't challenge that unless they challenge the validity of the donation Mortis Causa.
Sure.
And my practice is actually busy with 2 or 3 applications that are challenging a will at the moment. So it happens.
Yes.
So if that person that would have inherited in terms of the will, but has now been dispossessed of that through a donation Mortis Causa,
Yes.
they can feel, let's challenge that donation Mortis Causa. Did the person have, were they in the right mind? Did they have the capacity to give the donation? What did it follow the strict formalities that are required for a donation Mortis Causa, and all those things? So it is challengeable, but it will be very difficult to reverse that if it was done properly.
And correct me if I'm wrong here. The way I see it is, a donation Mortis Causa occurs before the death. In effect, the donation happens the day before I died.
Yes.
Right.
Yeah.
The will deals with my assets post my death.
Yes.
Right. So
Yeah.
technically, the asset no longer is part of my estate in the event of post my death. So there's a bit of a break there, and that is easily debatable, contested on that
Yeah.
basis. So I fully agree with you. The only real degree of challenge would be, is this donation valid, or was it real, or so on? And they contest the document itself.
Correct.
But the principle isn't really contestable on that basis.
Yeah.
And then over and above that, South Africans that generally invest offshore, in some jurisdictions or many jurisdictions, for those assets held offshore, would require a will in that jurisdiction to deal with that. Now, this goes back to what our previous question was. A donation Mortis Causa can absolve the need for an offshore will in that instance, because I've donated that. I don't have an offshore estate really, because I donated it the day before I died.
Yes.
Could you dig into that a little bit?
Yeah. So that would reduce your need for an offshore offshore will, and that you have this deed of donation that you have to give effect to. The interesting thing would be choosing your jurisdiction for that. So being in a country like France that's got forced airship, that can you donate that asset in French law, and
Sure.
And that's something that you'll have to get advice from a French lawyer. But most certainly that document is a legal binding document, and that if there's a conflict of laws, then you have to then fight it out. If the jurisdiction says that you cannot, disinherit someone from an asset, and you've got a donation Mortis Causa that has, what is the validity of that donation Mortis Causa? And I think it'd be hard pressed for that country or that jurisdiction to argue that the donation Mortis Causa is invalid because it happened during your lifetime. You did it during your lifetime while you were still alive. You contemplated it. It's a donation. So yeah, it's an interesting question. Interesting to see how that, if that ever plays out in a situation where there is a conflict of laws.
Great. So I think in closing, in your mind, if I would say to you, give me 3 to 4 key benefits around a donation Mortis Causa that it would have to a client or an individual implementing this, what would those main factors be?
Yeah, thanks. Firstly, it's not a tax benefit. You've got to understand that doing a donation Mortis Causa is not about tax.
Yes.
It's about ease of administration. It's about getting the asset into your hands sooner rather than later, having to avoid the winding up, especially for a situation with CIG and the assets in the CIG, is to get that asset into the person's hands quickly so they can have the cash, they can use it they need to, so that they can actually move forward with their lives. A big thing about a deceased estate is that people never get closure. It takes a long time for them to get closure. If they can then receive the asset, it's done. It's what my mother or father wanted me to have. It's a clean break, and then they can move on with their lives. So for me, the key takeaways is that it's quicker. It avoids lengthy administration. It's a nice way of getting money into someone's hands without the administrative burden on them. It reduces potential costs. Executors' fees is another saving factor. So those are the considerations. But obviously, get advice because of the nature of a donation, not being like a will, so you can't have successive situations or can't make a contingent on other aspects. So that's it. So so for me, it's a very nice way of getting money into someone's hands without the complexity of winding up an estate.
Yeah, I think the way I see it is that from a benefit perspective, I would say it's number one, it makes simplicity is key, right? So it makes winding up an estate or an asset or portion of an estate or portion of assets much simpler and much easier. I'd say cost effective. You don't necessarily need an offshore will in certain instances. You don't necessarily need to pay an executor to manage that asset and additional fees and so on that go around that. And ultimately, it's not a tax loophole. It's actually got nothing to do, because you're either going to pay in your life, you're going to pay donations tax, or you're going to pay estate duty, right? And I kind of see donations tax being like early estate duty. Really is what it is. It's estate duty in disguise. But the reality is you're not trying to cheat SARS or anybody out of what is due to them. So it works in principle on that, and that makes the ultimate benefit then for the people that stand to receive your assets in this instance a much simpler, less stressful, administratively burden less burden to do that. So Ulrich, in closing, I think one of the key things that still stand out here is that although this exists and it's a solution and it's implementable, it just hasn't really been tested in day-to-day life, right? And there are a lot of key discussion topics and nuances around this and how you can use this. What would you say to that to build on it?
Thanks, Ashley. I think it is untested in the administration space, how it is administered. There's nothing illegal about it. It's implementable, as you said. It's a accepted principle in South African law, common law, donation mortis causa. It's for me, and I'd love some colleagues that have dealt with donation mortis causas and seen the implementation of it, especially in relation to the master
Yes.
of the High Court. How did the master deal with it? How does the master, engage with donations mortis causa? Do they accept it? Do they want you to mention it in the estate? Especially when you have to transfer the asset, especially a property. So I would love engagement from my colleagues in the legal industry or tax professionals that have dealt with this to engage on it, because it is a nice solution for many people to avoid having to go through the horrible process of dealing with the master of the High Court. That's
Ultimately, a benefit to society.
Correct.
And I think definitely room for added discussion and exploration on the possibilities around it. But thank you for joining me today, Ulrich. Always a pleasure.
Yeah, great.
I'm pretty sure there will be many more questions
Absolutely.
as we build on this.
Yeah.
But with those few words.
Yeah, cool. Thank you. And thanks for those engaging questions.